Continuing with our theme that the medium is the message, Norman Pearl is the founder and owner of the National Audio Forensic Laboratory. His firm specializes in audio evidence, tape recordings, and voice print identification, and offering forensic testing of evidence tapes. He's qualified as an expert witness and has testified in state and federal courts, and I know that you'll enjoy his presentation. Norman, it's all yours.
Thank you. The title for this talk is Sound Decisions, and it's my intention to give you some examples of some dramatic cases that are currently in the laboratory, maybe some additional information for you to use that you normally would not have when confronted with audio evidence, various aspects of it, and to show you and explain to you examples and the list of services that my lab offers. Making sound decisions. This is the first time I've used this display, by the way. I don't think it'll be rough, but this being the list of services that my laboratory offers. Tpr Analysis. Tpr Analysis, for those of you that may do criminal work, is a new form of tape recording which will be used by law enforcement. TPR is an acronym for tamper-proof recording. It's a process put out by 3M Company, their law enforcement section, and is a very complicated and exotic way of doing tape recordings. Technically, it also puts a digital track on the evidence recording, and that digital track allegedly will give you the date that the recording occurred, the time, and various technical information. Their marketing of this product under tamper-proof recording got me involved in that I was one of the experts in this country that, in the private sector, that was offered an opportunity to evaluate this product, and I had it in my lab for about 6 months and ended up telling them that I thought they ought to change the name and not use tamper-proof recording because it wasn't. Recording conversions is a service that we offer that has to do with an attorney receiving perhaps a mini cassette, a micro cassette, certain off-speed or surveillance speed reel-to-reel recorded evidence. That was scary. Recording conversions will take that audio and format it up to a standard cassette, which is a common service. Recording duplication, there are many times I have found that the evidence recording needs to be offered to the various parties in litigation, criminal or civil, in multiple formats. So we offer high-speed duplication. And we also, high-speed duplication only occurs on tape recordings that are 90-minute cassettes. When you get into 120 or the surveillance speeds, which go in the matter of like 4 or 5 hours per side, those are done in real time, and our lab is equipped to make standard speed recordings. Voice print identification. I put asterisks on some of these services because I need to tell you certain things about it that normally wouldn't be in a presentation. Candidly, I find that most of the cases I receive with voice print identification involve recorded threats, garbage, obscene calls. It's very rare that a litigant or a defendant will be presented with a recording of their voice and having them say, that's not me. Most of the time, it's working with an unknown recording, unknown being a short death threat, threat of violence, extortion, or blackmail, or garbage, obscene calls. And I wanted to tell you that most of my testimony and experience in this involves a report that says, gee, this recording is of such poor quality that one cannot technically or impartially offer an opinion as to the identity of the speaker. And that has been a great help to the attorneys that I'm dealing with. When a client is saying, I didn't do that, and someone is saying, gee, it sounds like him, and based on that, this person's going to be in trial, I think it's important to have someone qualified to be able to give a presentation that the audio on the tape, for whatever technical reason, really can't be used as a basis of strong evidence to identify or disqualify someone. Important information technically on this is that the FBI, as a rule, a standard rule, will not accept a tape recording for voice identification unless it's a string of 20, a minimum of 20 naturally spoken words. So if you get a case where a tape recording is somewhat muffled, I'm going to kill him, or any of the other wonderful things that I hear regularly, that's just useless. There's no way in a distorted voice that it can be used, even if it's a murder case. If the voice is distorted, if I'm the expert that comes up and says, gee, that's just useless as far as identifying somebody, I don't know why it keeps doing that. The voice itself, the opinion of the voice itself will, let me make sure, is a subjective analysis. The subjective analysis means there's always going to be another expert that's going to give the other side, and it really clouds the issue. Accurate transcript service is a volume business that I conduct. Accurate transcript service is not just being a stenographer or a cleric. It is working with tape recordings that are extremely difficult to hear. It's working with a tape recording from which you have received a transcript, and in that transcript, the word unintelligible appears an inequitable amount of times. Because of the instruments that are used to filter, clean, analyze, and the intense listening through headphones, accurate transcript service is something that comes about because when it's not feasible to make a re-recording, a cleaned recording from audio that's difficult to hear, one can still hear the words. And as long as each word is discernible, the transcript can be certified with the declaration and, of course, followed up with testimony. And I have examples of that that I'm hoping to be able to play. Expert witness testimony. I've testified in more than 30 trials, local, federal, and foreign courts, where I might say I've survived close to 30 voir dires. Come on. Murphy's Law with electronics. Noise removal, sound enhancement. I have an example from a case I did the latter part of '89 that I think you'll find as dramatic as I did. Noise removal, sound enhancement is very straightforward. It's a process whereby I don't use just a graphic equalizer. I have some exotic filters that are computerized, and one identifies the frequency you want to eliminate or the sounds that you want to enhance, and by passing it through the filters and making a number of re-recordings going back and forth, one increases the intelligibility, and I hope the example impresses you. That is possibly not the next slide. Videotape recording evaluations is another very straightforward process. I can tell you war stories about, gee, that's really distressing. I could tell you war stories about watching a videotape that has a time-date generator going and the defendant involved in the incident seeing what they call a roll, where a bar just goes from top to bottom, and there appears to be no break in the continuity of what you're watching, but if one uses the proper equipment and goes through watching the time-date recorder, in the particular case I'm talking about, 9 seconds just disappeared. That particular case involved an attorney that was being prosecuted for shoplifting, and amazingly enough, this roll of 9 seconds being lost occurred when the alleged crime took place. As he was reaching for the shelf, the security people said that he put something in the bag, and when the camera came back, he was down at the bag, but it rolled so fast that cut was hardly discernible by the officers that took him into custody and the other security personnel of this major department store. And because you're watching something or listening to something that you instinctively accept as authentic or real, these little discontinuities seem to go by. And to digress for just a moment and tell you that there are qualified studies wherein when one reads a transcript while listening to a tape recording of the incident, if there's a discrepancy in the audio version, what you're reading is what you're going to retain, and you'll bypass what you're hearing. A case that I will show you, or let you listen to, which was a very dramatic case where one word made the difference in the sentencing of an alleged murderer. Let me try and fix this. So much for the visuals. I have no idea why that. I know it's a plot. Evidence recording authentication is the primary function National Audio Forensic Lab offers attorneys. You'll get a tape recording. It'll sound just fine. Your client will say, gee, I don't remember saying it in that manner. Or he may say, where's the rest of the conversation? Where's the phone call that I made that says I'm not going to do the deed? Or any number of wonderful excuses. But when you listen to the recording, you don't hear anything that would be suspicious. It's those clues that your client give you that I believe really makes it cost efficient to have the recording analyzed, have it looked at and listened to by someone who does just that, someone like myself. Evidence of splicing and editing, which is my last demonstration, should convince you that this state-of-the-art has come about now where this can be done relatively easily and without any real technical signs that this has been done. This is a case I'm involved in right now. The war story is that a woman came home and found her family murdered. She picks up the phone and she dials 911. Oh, hysterical crying and screaming, please come and send police, send an ambulance. Dispatcher says to her, do you know who did it? The female responds with, I think so. He says, is he there now? And when he says that, this is what happened. I'm going to need some volume for this. This is a very small segment of this particular section of that recording. It goes on for a gruesome amount of time. But you can hear the guy in the background screaming, and he's screaming something over the woman's scream. And he also was in between her taking breaths where there was some silence, he's still talking. So the prosecutor wanted to know what this person was saying, and they sent it to the FBI lab, who kicked it and said that there was nothing they could do. The defense attorney found me, and I was able to filter out a great deal of that screaming and come to an opinion as to what was said, and really there wasn't anything dramatically revealing. It was a series of obscenities that were able to be discerned. But the most amazing thing on it was this. This three-word phrase comes from another part of the room than this one. And right after that, this other voice popped in. So that's very dramatic evidence. I called the defense attorney. I explained to him what I had found. He requested me to prepare for testimony. The prosecution challenged my credentials under Kelly Fry. FBI analyst flew in from Washington to discredit me. They failed. The evidence was presented. A mistrial was declared. This trial is currently underway now, and next week I'm going up to re-present this evidence, which I think is terribly exciting. It gives some doubt to the defendant on trial as to being the only assailant in the room, maybe a co-conspirator, and these issues from the information I have are going to go to whether this person gets the gas chamber or a life without parole. This is the most traumatic case of cleaning a recording for a client that I ever had. It just, when it works, it's magic. When it doesn't, I'm just not the hero. Most of them work. Most of them, the intelligibility will increase. Here was a situation where a person was accused of an incident in the sky. The attorney was or is a pilot and handles FAA hearings. And this is what it sounded like when I got it. And this is unaltered. I don't know if the speaker carries the real finer points, but underneath that hum is audio, conversational audio. And what that particular sound is the digital track on a 24-hour logging recorder that says the date and time. So processing this, you have to listen carefully, but...
That's a 713 say again.
Which I felt was really dramatic, and I'm really proud to offer that as an example of what we can do. Coincidentally, the defendant in this situation, regardless of the fact that there were technical showings that his transmissions weren't on the tape, and the official FAA transcript was extremely inaccurate, the man's license was still suspended. This is an example of signs of editing. What you're looking at on the top frame is a waveform of audio. Just in the interest of efficiency to show you, there's not a lot of words that you'll hear, but just a short few seconds of sound. In the sound towards the end, there's a very unusual noise that most people would not pick up on unless you were pointed in that direction. Wrong one. Just about where it flashed, there was a very high-pitched sound. The particular case, which is a current case in Los Angeles Superior, of a person accused of murder, This is a segment that was taken from a conversation with a wired informant, and the defendant said, gee, I remember him asking me that question. We had a long conversation about it, and I don't hear any of that conversation. What we look at here on the bottom part here is that particular sound, which was that high-pitched whine. And these marks here, which you'll see more of at the end of the presentation coming up shortly, and this mark here are the marks normally attributed to the recorder being stopped. I have no real explanation as to what that high-pitched whine came from, but these marks here are in inappropriate places. When one pushes stop on a tape recorder and the head is removed, there's a burst of electrical energy that hits the tape and makes a specific mark, and it's commonly referred to as a signature, a tape recorder signature. But just to try and pick up that sound again. I hope you were able to hear it. It supports the man's contention that the conversation is not complete or in context, and probably is not the total amount of words that were spoken at the time the recording was made. This was the sensational murder case a few years ago in Pasadena, which was referred to as the Domino pizza murder. Young couple from someplace in the South came out here, ordered a pizza, and killed the pizza delivery man. A gruesome crime, no rhyme or reason. I don't even think robbery was the motive. But the male of this couple was the perpetrator of the crime. The female was the co-conspirator and did not have physical complicity in the crime, although she stood there and watched it. And the defense attorney argued that there wasn't anything wrong, other than morally wrong, in her being there at the time, as long as she didn't participate. I believe the male got death, the female got life without parole. I was told by the attorney that this testimony regarding the transcript that the district attorney presented was a major factor in the split of the sentencing. What you're going to hear is the original version, and the critical sentence is down here at the end, where it says, "'Cause all it was doing was pushing his face down under the water," and this is an example of what you're reading and what you're listening to. This may sound a little clearer. District Attorney's version of this transcript, which is where the arrow is, said, "All I was doing was pushing his face down under the water." This caused a real sensation in the trial, and the following day, the newspapers and media reported that this woman had confessed to physical complicity in the murder. And just as a side issue, what really happened here is the attorney and the jury and everybody was sitting there reading along on this transcript, and by some quirk, the attorney dropped something just as this section was going, and when he bent down to pick it up, he stood, he sat back up, and everybody was going, "Ooh," like, oh, she had confessed, and he didn't hear that. So that night he brought it over to me, and that was a Thursday night, and I was prepared for trial on Monday morning and testified Monday, Tuesday, and Wednesday as to the gross inaccuracies of the DA's transcript. I'm sorry you can't see this. Here's another war story, but a terrific story for you to know. This case involves a woman who was running for office in a large town. She was running on the ticket of legalizing massage parlors, and she had a darn good chance of winning. And the night before the election, she was arrested in her massage parlor for soliciting an illegal and immoral act by the officer. That act was recorded. The defense attorney in this case was remarkably impressed with how clear that recording was. I mean, it's a very unusual thing for those of you that get recordings to have one come out clear. It always amazes me how terribly bad and poor the audio is in evidence in most cases, where I just see the worst side of it. In any event, this is how the evidence recording appeared at time of trial. Tape got to me with a request to find out if this tape had been altered. So the defense attorney makes a request. I also have to tell you that in this particular jurisdiction, there are no certified court hand reporters. There are microphones. I mention this really emphatically so that you're aware when you walk into a courtroom whether there are microphones on the table, and if there are, you should be aware this is an amazing example. The defense attorney makes a motion. It may get garbled at the end, but she wants to preserve this evidence for the forthcoming civil trial.
Your Honor, I would only request that there is a tape recording and keep it out there. There's been an order that it not be destroyed. I would ask that that order continue because of pending civil action or contemplated civil action in connection with these cases, and that would be evidence that we do not want to destroy.
And it goes on and on. But what occurred was the district attorney in this area leaned across the microphone to the prosecuting attorney and said clearly, wait till you hear what's on the tape now. They had altered the tape. The tape was in the sanctity and custody of the court. So when somebody says, well, the tape's stored and it's in the court evidence locker and certainly nothing could happen to it, I'd like you to remember a case like this. Just an amazing revelation that evidence could be falsified in this manner, rendered useless while it was in an evidence locker in the court. The minor stories that go along with this are that, recognizing the seriousness of this situation, it was decided that the testing of this recording would only go to the point of subjective opinion and not an objective finding by virtue of a forensic analysis, so that should it have gone further to an objective analysis, it would have turned into a Department of Justice case. The mayor, the chief of police, the investigating officers, probably the magistrate, and half a dozen other people would have been rather embarrassed. This is a waveform showing the signature of a recorder when it stops at the end of a recording. This bar here is the pattern of energy coming through the record head. This pattern here is the pattern of energy that comes through the erase head. I find these all very unique to each recorder. It's testing of these particular signs and finding them that allows one to confirm whether a recorder is in context and admissible by virtue of starting at the beginning and stopping at the end, or whether some hanky-panky may have occurred. I want to give you, as the final demonstration, an example of what can occur. It just will take me a moment to boot up and show you this. And while I'm doing that, I want to mention that the theme or the guidelines that I operate in analyzing a recording follow the guidelines that the federal courts have laid down for admissibility. In a case which is USA versus McKeever, the McKeever elements, as they have been lately called, are 3 or 4 guidelines. And number 3 is a guideline that states that a recording should be free of signs which suggest falsification. And there are many technical deficiencies which can be attributed to mechanical failure, but there are a specific set of circumstances which would address an area of falsification. It doesn't necessarily mean that it couldn't have been an accident, but for a recording to be admissible, basically it has to start at the beginning and stop at the end. Let me kick this in and show you this. Another wonderful test. This is an online waveform analyzer. And the phrase that I want to show you is, "I did not kill Peter." Whoops, that didn't work, did it? And the phrase that I want to show you is, "I did not kill Peter." And this is what can be done with it. And the phrase that I want to show you is, "I did not kill Peter." First thing one would do is take this area here, which is the phrase that I want to show you is, and get rid of it. "I did not kill Peter. I did not." "I did not." And the word "not," which is right here, "not," will go. Now there's no technical sign that this ever happened. "I did kill Peter. I did kill Peter." And the phrase that I want to show you. And that concludes my presentation. If anyone has any questions, I hope I can answer them. Thank you. Oh, I'm sorry.
One question.
Sure.
Every time you play a recording, aren't you, in a sense, altering the original? And how do you analyze the tape for purposes of coming to your opinions without having that argument come up?
Most of the recordings that we receive are re-recordings that are work copies presented to the defense attorney. But specifically answering the question, yes, it's so technically insignificant to play a recording once, twice, or 10 or 25 times and distort that recording. For my purposes, most of the recordings that we get when they are original recordings, they're digitalized. I use digital tape recorders, and we make a work copy. A digital tape recorder essentially is an extra original. It preserves all of the frequencies as they occur. There's no signal to noise, no tape hiss type of thing with that. So we work with either digitals or re-recordings mostly. And then it is our endeavor to find technical deficiencies which would support a motion to release the original for forensic analysis. Is that it? Thank you.
Thank you, John. Can you keep your materials in place here?
Yeah, I'm just going to shut it down.
Okay, good, good.
start with.
Live from Channel 2 and first in the Bay Area, this is the award-winning 10 o'clock news, the #1 primetime newscast in the country.
Good evening, I'm Elaine Corral. Switzerland is on assignment. And coming up on the 10 o'clock news, it's been known as the yuppie dream car, but a South Bend man has a horror story to tell about his BMW. And in Libya, a mysterious fire strikes a chemical plant that's been a flashpoint between Libya and the United States. We'll be right back.
When issues of agility and precision take on special urgency, we recommend the BMW 5 Series. Its unparalleled defense system is designed to help you emerge unscathed from a hostile world.
The letters BMW are almost magical for car buffs, especially for those who can afford the price. BMW, or Beamer, has long had a reputation for, among other things, performance and safety. In the South Bay, there's a man who says thousands of BMWs are unsafe and he wants them off the road. He's Dr. Paul Chin, and he hoped to be an astronaut before he was severely burned in an accident involving a BMW. Lloyd LaQuesta reports.
This is a picture of a 1969 BMW 1600 Paul Chin was driving 6 years ago when he was rear-ended by a drunk driver. The gas tank ruptured and the car burst into flames. Today, Chin showed the scars he is left with because of third-degree burns over 65% of his body.
Next time you ride the BMW, drive when as a passenger, buy one for your children or your spouse, drive behind them and drive next to them. It's what happened to me.
There were some 600,000 of the BMW 1600 and its companion model, the 2002, made from 1966 to 1973.
It's a cute little car. Young professionals like it. You drive around in it, unaware. That is, to me, a death trap.
Chin sued BMW, which settled out of court for $1.7 million 2 months ago. But he and his attorney say they want the car recalled. The issue is whether the gasoline tank, which fits in the trunk, was placed in a dangerous and unprotected location. Attorney Richard Alexander says BMW knowingly produced a car that was unsafe.
They have a public trust. A lot of people rely on BMW. And BMW has an obligation to tell them that this vehicle has an extraordinarily soft rear end and the gas tank and the fillets will break loose at a very low speed.
BMW officials in New Jersey today released a statement saying, quote, a spare gas can was found at the scene near the car, which may very well have provided fuel for the fire. And BMW also said the kind of car in question has been used by the driving public all over the world. The San Francisco attorney who represented BMW says the sympathy factor toward Chin's burns was one reason for the out-of-court settlement.
I don't want to question Mr. Alexander's motivation.
The hell you don't, Carlson.
Members of the bar are also interested in the economics of their law practice, and I suspect that there's a substantial element of Mr. Alexander's concern for future business, and I think he'd probably like to engender further litigation on his own behalf.
Chin says some of his settlement money will go toward establishing a foundation for burn victims. An appeal has been made to the Federal Department of Transportation to have these cars recalled. So now, it's up to the government. In San Jose, Lloyd LaQuesta for 10 o'clock news.
It was curious that in both of these runs, at least for this particular, for this station, BMW is able to buy advertising time both before and after, and I won't bother you with the second ad, but they're doing their best to correct the record here. Well, that's a very brief overview of what the Chin case is all about. What I'd like to do this morning is to share with you a complete view of this file as it came to our office and what we had to do to try to put it into a position where it could be tried, and why this case settled. In my own opinion, the injuries here far exceed the recovery that was obtained, but this case had some rather serious problems. We didn't have a vehicle. The actual Chin vehicle that's displayed on the walls here that you'll see in the videotape mysteriously disappeared within a period of several weeks after we were called into the case. What we do know is this BMW has a drop-in gas tank, and the cutaway of the vehicle is here, and you can see the tank is actually a structural part of the vehicle. The tank itself is made of carbon steel, and it's designed to actually drop into place into the rear of the car. To understand this lawsuit, all you need do anytime this morning, and you're welcome to do it, is to come up here and to lift up this 1/6 or rear portion of the vehicle, the rear quarter, and you'll find there's nothing here. You can easily lift it with one hand. There's no frame. It's nothing but formed sheet metal, and the bumper provides absolutely no protection. It's extraordinarily thin. You can stand on it. I've tried that. I was going to do it at trial. You can stand on it yourself. It doesn't take much weight to actually bend this rather flimsy bumper. This particular lawsuit was in litigation for 4 years. It was very thoroughly prepared. I've been involved in others that have been nearly as well prepared, and this one is right at the top of the list. The BMW 1600 in 2002, there were nearly 600,000 of these vehicles sold across the United States. Our best estimate is that approximately 108,000 were sold in the United States, and we were particularly interested in the model between 1966 and 1973. You'll notice that all of these BMWs have round taillights. Those round taillights are indicative of this model. Beginning in 1974, BMW changed the design. They put on a substantial bumper in compliance with federal standards for a 5-mile-an-hour bumper standard, and they reconfigured the gas tank. But these photographs, which were taken across the Bay Area, some in San Diego, some in Los Angeles, throughout California, we identified these vehicles because we wanted to show that this was not simply an old car. It's a car that is looked upon by many as a classic. It's looked upon by some as a collector's item, when in fact it presents an extraordinary hazard to anyone who might drive one and be rear-ended. This is one that I photographed just a couple weeks ago on a car lot in Sunnyvale. Here's a photo of Paul Chin. This is what Paul looked like before his injury. This was the Christmas, the year before, December 1984. Our first contact with the case was from a referring attorney who sent over the police report. As you can see, this was a hit-and-run case. Chin had been rear-ended late at night, 1:30 at night, in San Mateo County. He was on a freeway when he was struck from behind, and the vehicle involved was later identified as a '74 Camaro. The police weren't sure exactly who owned the vehicle. If you look at the lower left of the screen, you'll see the accident diagram showing the vehicles being rear-ended and proceeding to crash into a median barrier before it came to rest. The police officers noted that there was 265 feet of locked wheel skids from the vehicle and 125 feet of gouge marks on the roadway. Their opinion was that the a rear-end collision was at high speed. It caused our vehicle to lose its gas tank. The Camaro, or D2, was traveling at such a rate of speed he was unable to slow his vehicle and struck the rear of this 1969 BMW. Later that evening, the police identified John Reiser, and they went to his home and they spoke with John Reiser. They didn't take a blood alcohol, but they when they spoke to him, they detected a very strong odor of alcoholic beverages. His eyes were bloodshot. They asked him if he owned a Chevy Camaro that was involved, and also if he'd been drinking that evening, and he reported yes that he had. The first criminal trial that Reiser had to defend ended in a hung jury. He later pled guilty and was sentenced to 3 years in the Department of Corrections for this collision. Reiser, at the time of this particular crash in December of '84, not only had been drinking, he was a convicted felon. He had been previously convicted of kidnapping. This is the accident location, Highway 92 in San Mateo County, typical freeway. The Reiser vehicle, this 1974 Camaro, look at the damage. This will be interesting when you look at some of the crash testing we did later on. This vehicle was driven from the scene. It was rebuilt by Reiser, and in fact had been sold by Reiser to his brother. It is still on the streets today. It's being, you may see it on the road in San Mateo County, where it's presently being owned and operated. Most of the damage was cosmetic. They took out the grille, and you'll notice the bend in the front fender. Other than that, the vehicle sustained very little damage other than the bending of the steering wheel. The fire department reported that when they appeared on the scene, the vehicle was completely involved in flames. They released the vehicle to a tow yard. Here you can see the skid marks of the BMW as it proceeded into the wall. We hypothesized that the vehicle was on fire at the time it hit the wall, and that was the reason for these smudge marks. If you look down in lane number 1, there's a vehicle in lane 2, and to the left of that vehicle in lane 1 is a mark on the roadway. That's where the Chin vehicle came to rest. And that mark is a burn mark. You'll also see some other scrapings along the wall, which was the path that the BMW pursued until it came to rest. Our analysis indicated that the vehicle had arced in a leftward arc and had hit the wall with its right rear, had rotated off the wall, and had come to rest doing a 180 turn before it finally stopped. The defense theory in this case was that the vehicle, after it hit the wall, rolled. And the reason they had to have that theory of rolling is because this gas tank took such a major hit that they were going to lose on that theory, and they had to come up with another argument as to why this vehicle lost as much gas as it did. That was one of the items of contention throughout this case. See the skid marks here coming into the wall, and you can see the smudge marks that were involved. These photos were taken by the Highway Patrol one day after the fire itself. You can see the scorch mark on the driver's door. You notice the scratch marks. Those were in heavy dispute throughout this case. And the gas tank has been, the rear end's been taking a pretty solid hit. You'll notice the gas cap is on in this photograph. In fact, the gas cap was found lying loose at the scene. It has evidence of scratch marks on it and had been rotated, or it had come off in the course of the collision sequence. One of the Highway Patrol officers put this gas cap back on for the purpose of the photograph. He went to the scene the next morning, found it, and then proceeded to put it back in place without telling the criminal defendant that they did that until the second trial. So those of you who are doing criminal defense, there's a note for you. We took Reiser's deposition. We were at the Salt Creek Conservation Camp in Pasquenta. That's about as far north as Chico, but to the west, back in the hills. Reiser testified that when the car hit, he knew immediately that there was a fire. He didn't know whether the fire was in his car or the other car. He knew he had to get out. When his car came to rest, the other car, the BMW, was completely on fire. He reported it was probably less than 2 seconds, which wasn't a bad report. Our analysis was that it took about 4.5 seconds from initial impact until the vehicle came to rest. So for being a layperson involved in a collision, 2 seconds isn't a very bad estimate at all. The main reason I got out, I know I was thinking something is on fire. And he wasn't sure whether it was his car or the other car, but he knew the whole car was burning. I knew there was a fire there. What else did he tell us? During this quick period, he reports that he saw flames billowing approximately 15 feet high. His entire view of the BMW was covered with flames. It was a ball. He said he was in shock. He had been very surprised. The whole accident, and my conclusion was that whoever was in there was dead. He said if that car probably would never have lit on fire, I never would have ran. He saw such a large, huge conflagration that he fled the scene. He was able to drive his Camaro without any difficulty, and you'll see in some of our later crash tests that you can inflict substantial damage on this vehicle and still have a drivable bullet car. This was an accident that he didn't particularly expect. He reports that there was a huge billowing effect, and one of the themes that I liked in this case was the one that he came up with, line 27. He reports that the fire was kind of like a storm in itself, and it really doesn't take very much to let loose this storm. He said there was a major billowing effect, and the fire got worse as he observed it happen. There was no noise other than the fire, no screaming, nothing out of the ordinary. Nobody was calling for help. He stood outside the car for a brief period of time. He said it was less than a minute, and then he fled the scene. He was attempting to pass Chin on the right when this accident occurred, and he said it was almost to the point where I could have clipped him if there had been 1 second more time. Before that time, he had been involved in 5 accidents, and he reported this one, based on his own background and experience, as being a moderate hit. With regard to the damage, he says he didn't even replace the bumper. The left front headlight wasn't damaged. He was able to reuse it. The identification lights on the side of the vehicle worked well. The left front turn signal didn't present any problem. He was able to reuse all of the vehicle. There was no damage to the left front wheel, no damage to the steering assembly, and all he had to do was straighten the steering wheel to get it to work. Paul Chin's deposition testimony said that he was driving along Highway 92. He was hit in the rear. There were flames right away. I was on the ground, rolling around, trying to put out the flames on my body. It was just a minor bump. I would say it was moderate, he reports. Do you actually recall the fire starting, or is it just you have a recollection of fire? And Dr. Chin reports that he saw the flames. Where were they? There were just flames, complete flames. Were they just all around you? Answer, all flames. Do you have any recollection of where you were at the time? No. Do you have any recollection of getting out of the car? None at all. He says, I was inside the car, there were flames. Next thing, I was out on the ground, rolling around, trying to put out the flames on my body, on my legs. Your next recollection is rolling around on the ground, rolling around, trying to put out the flames. All I remember is there were flames all over, and I was looking at my legs. That's all I remember. I was horrified. That's the same Beamer that Paul Chin had contact with and caused these 2nd and 3rd degree burns. These actual drawings are here present for you to look at. They were done by Maria Reeves. She's in Berkeley. She's available. She's had work as a medical illustrator, has done medical illustrations for NASA, and she put together these drawings along with working with Dr. Ronald Sato, who was at the Burn Center at Santa Clara Valley Medical Center. But these graphically describe the actual cooking that Paul suffered. You'll notice that most of the damage is to his hands and to his legs. We were able to obtain the actual photographs, and you'll see that he suffered major burns to his legs, to his lesser burn to his back, protected by the seat. Those are abdominal burns. You notice this is a very interesting photograph. Paul was wearing a seatbelt, and in this collision, he did not obtain any bruising across his abdomen. That's because it was, in fact, a moderate impact. Hands were badly, badly damaged, as well as his face. This is a photo of Paul that was taken in January. He still wears Job's garments. As you can see from the television interview of Paul, his face has healed substantially. His medical bills are in excess of $500,000. He's had outstanding medical care. The vehicle, after the collision, was taken to D&M Towing. When I was called into the case, we went to D&M Towing to find it. It was not there. We found it at a junkyard in Novato, California. It was being stored by Aetna. Aetna had agreed to hold it, to protect the vehicle, and to keep it secure at their yard at a place called McAndy's in Novato. These are the only photographs that we have of the vehicle. You can see the scratches to the, back up for 1 minute here. This is where the vehicle took the hit into the wall with the right front after the initial rear ending. You'll notice the tell traces of some scratching, either with the median itself or in the course of a rollover. That's Don Basham in the back. Don is a former mate officer. He was sent out here to look at this vehicle to get some initial, so that I could get some initial understanding of what speeds were involved in this rear end collision. This photograph is interesting. You'll notice some bowing of the left A-pillar. That occurred during the course of transport. We believe it was done by a forklift. But the most interesting aspect of this photograph, look at the left rear quarter panel. It's intact. Also observe the trunk lid. It also is intact. When you look under that trunk lid, you'll see two main structures. On the left is the spare tire, and on the right is a ballooned gas tank. This photograph was interesting because as you look through the filler opening, you can see daylight on the other side. The filler tube itself had burned off in the course of the collision. Look at the deformation of the rear of the vehicle into the wheel and into the tire housing itself. There's another shot of that rear end. These photographs were important because this vehicle disappeared in approximately 2 to 3 weeks after it was photographed. So here we were in a major products case with a major injury without having the evidence to prove the case. One of the questions in our mind was what was the actual extent of the deformation that was suffered on this vehicle. In order to do that, we engaged in a computer photogrammetric analysis. We used Axel Hoffman. I got to hold ahead of my story. Let me back up for 1 minute. The vehicle disappeared. We called Aetna, spoke with Karen Pumley. She told us that upon contacting the salvage yard, they were told the Chin vehicle had been previously disposed of. We were unaware of the disposition. We had not authorized the vehicle's disposition. That turns out to be of significance later. So we're going into a products case. We start looking at literature concerning BMWs. This was out of a BMW yearbook telling us about the years that this particular vehicle was in production. I'd like you to look very carefully at the top photograph of this 1974-2002, and you'll notice the bumper has been changed. And that was because in 1974, BMW put a high-impact bumper on the rear end, and they also added a rubber corrugated shock absorber along with 3 major structures in the back. This 1974 BMW can be identified because it has square taillights. They also reconfigured the gas tank, and we'll talk about that in a little bit as well. So we do have the same vehicle with major subsequent changes, and I contend that those changes were made because BMW knew that this vehicle could not meet any of the crash standards that were in effect in the United States or in the world at the time it was produced and sold. The 2002 was sold here from 1968 to 1976. There's absolutely no difference in the body styles between the two vehicles. They're known in-house as body style 114. The only difference between the 1600 and 2002 is the displacement of the engine. BMW's own manual shows that this vehicle has a gas tank clearly in the crush zone. You can see it in the far upper right corner of this photograph. The only other structure in the rear of the vehicle is the tire itself. When you look under the vehicle and put it on a rack, you can clearly see the area for the spare tire. It's interesting that the spare tire has a protective housing. The gas tank is a drop-in gas tank. It does not. This is looking from under the vehicle towards the rear bumper, and you'll notice the other major structure here is the muffler. So if you do have any involvement of the rear of the gas tank at all, you'll have gasoline onto a hot muffler, which is directly next to it. There's the view from the back. In many of the vehicles that we looked at, we saw tank damage. The tank damage occurred as a result of the exhaust pipe being collapsed into the tank itself, no doubt from people backing up into walls or bumping other vehicles. This is a photograph of the back end. You'll see the long rubber filler tube. That's distinctive for the model 66 through 73. This is the drop-in gas tank in place. And when you take out that gas tank, you'll notice there's sunlight and shadow underneath because there's nothing else beneath it. There's a photograph of the exemplar that we have here, as well as this is a 1973 gas tank. You'll notice it has a long filler stub. This is not a filler tube. This is a welded metal stub. It's 6 inches high. And this is a subsequent change on this vehicle. They changed the configuration of the filler tube itself from the 6-inch or 8-inch filler tube down to the soft 3-inch filler tube. And when you see the crashed reconstruction, you'll see, I believe this change was made, BMW denies this, BMW says this change was made in order to have a different configuration for emission purposes, for fume emission purposes. That's why they extended the stub on the tank. I believe they extended the stub on the tank because when it collapses, it tends to fold over and would contain gasoline and provides better protection. Here's a photo of the new extended filler tube stub, and up above it you can see the older filler tube, the older stub. The older stub is about 2 inches tall, and you can see here that this one is approximately 6 inches in length. BMW, in its own shop manuals, mixes and matches these gasoline tanks. And if you look closely, you'll notice here in the third photograph down, they show the photograph of the old filler tube, but on an example of how to remove the gas tank, you'll see here in the top photograph, they show the subsequent gas tank with a longer filler stub and a shorter rubber filler tube itself. Here's the photograph of those two filler tubes. The change was made on this in 1971 in the reconfiguring of the rear end of the vehicle. Don Basham, a former MATE team officer, does reconstruction analysis. He's out of Auburn, California. He testified that the speed lost at impact as a result of damage was at a range between 15 and 19 miles an hour, so that he estimated the speed of the Camaro was between 75 and 79 miles an hour, and the speed of our BMW was approximately 60 miles an hour, and he confirmed that, in his opinion, the actual speed differential was 15 to 19 miles an hour. Riser was going somewhere between 75 and 80. Chin was going approximately 60 miles an hour, and that's what caused the damage in this case. When I first looked at these photographs, it looked to me as if this was a much harder hit. I couldn't imagine that all that damage could be done at 15 to 20 miles an hour. I wanted to know exactly what displacement there had been of the filler tube. We didn't have the vehicle to actually make that complete exact measurement, so we hired a photogrammetry firm. This is Axel Hoffman out of Oakland. We had him look at it, and he confirmed that he found by actually taking those 3 photographs and doing a computer analysis, he was able to measure the actual displacement. And so we knew that the gas cap had been displaced a total of 12 inches in this collision, which is more than enough to upset that 6-inch filler tube. Our check of federal government records shows this 1971 case where the NHTSA had observed fuel leakage at the fuel sender unit being at the forwardmost portion of the tank. And it was interesting that they found on front-end collisions Because remember, a rear-end gas standard didn't come in until 1976. But on a front-end crash test, on the Federal Motor Vehicle Standards that were in effect in 1969, this vehicle lost gasoline at the sender unit when it went into a wall at 30 miles an hour. Francis Armstrong asked for a response within 30 days from BMW, and BMW responded. As it turned out, when I first read this, I didn't think it was that interesting. Didn't have much to do with the rear-end collision, but I went back and I highlighted the name Stork. And I'd like you to remember, this is 1971. The BMW has responded. Mr. Stork signed, and he told us something interesting. He told us that in 1967, BMW had conducted tests. They would lead you to believe by this report that they only conducted a test on one vehicle. As it turns out, in 1967, BMW conducted 15 crash tests. Their crashes numbered 2 through 16, and we learned a little bit more about it as we went into it. Here again, they report their tests of the model 1600 in 1967. This chart would lead you to believe that only one crash test occurred. In fact, there were 15 that were made. Also signing this report is a chief engineer by the name of Elsholz. And you want to remember his name because he comes up again in this scenario. We ran through and did a records check on BMW to see what was in the computerized databases, and we found that there had been some complaints about brake defects, and BMW was aware of the defects but had made no effort to correct, to recall, or to warn. And that's the strategy they followed in this case, and I think that's a strategy that BMW will follow in all cases. They'll defend very vigorously, they're very proud of their reputation, but in fact, when they do know things are wrong, they're not always going to step forward. The Atla Exchange, the Products Liability Exchange in Washington, D.C., confirmed there had been another lawsuit, a case called Sugarman. Mel Block, a former ATLA vice president who has since passed away and to whom I owe and you owe and everyone a great debt of gratitude. Mel Block was an outstanding lawyer. His spouse is an ardent advocate for lawyers. I had a chance to talk to her. She stopped what she was doing, went to their warehouse, pulled the Sugarman file, and sent it to me. And when I opened the Sugarman file, I found this police report. And in this police report, you'll see that Euless Bray was driving a Ford LTD owned by Betty Q. He rear-ended a 1969 BMW. This was an actual trial exhibit. That's a trial stamp from the federal court in Brooklyn. These were the photographs that were actually introduced into evidence in the Sugarman trial in 1982 before Judge Constantino. And you look, the BMW here has been rolled on its top. You are looking at the driver's side. At your far left in this photograph is the right rear end of a 1969 BMW that was rear-ended in New York. You can see the burn damage to the vehicle. Here, there's another shot of that right rear of the BMW. This was a photograph that was taken by an expert. This vehicle was put in a yard. We have these photographs to show us what the actual damage is. I'd like you to look at the right rear end and see how it's compressed up against the wheel housing. There is relatively little damage to the roof lid, the trunk lid itself. This is the Ford LTD that took out that Beamer. Not only was this vehicle drivable, when Euless Bray returned it to Betty Q, Betty Q didn't know it had been in an accident. Euless didn't tell her. He parked the car, she drove it the next day. It wasn't until that next evening that Betty said, "The left front turn signal doesn't work, Euless. Do you know what happened?" Euless said he had a little collision with a BMW. We found Euless Bray. With today's searching techniques, with a Social Security number, an address, maybe a date of birth, which we found in the Sugarman file. We were able to track him down. He was in Atlanta, Georgia. I've spoken with him on the phone. He's a 40-year-old man, very articulate. He told me the speed differential, as far as he was concerned, was about 20 miles an hour. He was on the New York State Thruway. They have gas stations in the median, as some of you know. He said Sugarman pulled off to go into the median gas station, changed his mind. He said, I accelerated to get past him. He had been going about 50, 55 or so. I stepped up from about 50 or 55 to about 60 or 65, and he swung back in. I think he was going about 45 miles an hour. I think I was doing about 60 or 65 because I was accelerating. Frankly, I was tired of sitting behind him, and that's when I nicked him. He said, I did not hit him hard. I was able to stop my vehicle, I ran over, and I pulled Jay Sugarman from the fire. So we know that what happened to Paul Chin happened to Sugarman as well. Relatively minor, low-speed hit. These are BMW's answers to interrogatories. They were less than candid when they answered these interrogatories back in 1978 or 1979 in the Federal District Court in Brooklyn. They tell us the vehicle had been manufactured for over 12 years by the time they answered these rogs. The gas tank was integrated into the trunk floor. Yes, that's true. This gas tank is a structural part of the vehicle. It's part of the crush that you would normally expect in a vehicle. Have you ever conducted tests on the 1969 BMW? Yes, they say. Tests were conducted with respect to the operation of the gas tank mechanisms after the car leaves the assembly line. You notice they have failed to comment on these 15 crash tests that were conducted by Professor Ernst Fiala at the Technical University of Berlin in August and September of 1967. It just kind of slipped through here. As a result of your test, did you make any changes? Well, that's a lie. They did make changes. Maybe not as a result of the tests, but they did make changes from the short stub to the long stub, and eventually they put on the heavy-duty bumper in 1974. They did tell us there were some tests of the gas tank in August and September of '66, but they didn't tell us about the August or September of 1967, which is the most interesting material here. They tell us the tank is underneath the floor instead of between the wheels to prevent penetration of inflexible luggage. Luggage penetrating gas tank? I mean, that was the level of their analysis back then. Was it installed in subsequent vehicles? The same thing, yes. State the name and address of all people who furnished any information. And I'd like you to notice Wolfgang Lang, and I've highlighted Jost Schmidt. He comes up several times. He's House Counsel. He's in charge of coordinating all litigation. He coordinates any claims from other governments. He lobbies on standards, and he also produces documents. If you have a BMW case, you too will have a chance to meet Herr Dr. Jost Schmidt. This letter by defense counsel for BMW was extraordinarily interesting to me, and you're going to find it extraordinarily interesting as well. It says here that they want to show an exemplar vehicle because since the actual automobile wreckage disappeared before our records could examine it. I know of two BMW 1600 cases that have been litigated in the United States, Sugarman and Chin, and in both cases, the wreckage mysteriously disappeared. August Achleitner testified. He's an engineer. He had been involved in the conceptual development of the vehicle. He was concerned. He was involved with the fuel tank and the placement of the fuel tank. He wanted it protected as well as possible. He said that when placement is too close, that in small accidents you can have considerable conditions or considerable consequences, is the translation from the German. He says, in deposition he says, there were some tests in 1967. They were conducted at the University of Berlin by Professor Fiala. There was one test. And he says there was a BMW 108, that was an error In translation, it's a BMW 1800. It's identical to the 1600, except it's configured differently for European sales. They crashed those vehicles at 67 kilometers, he tells us, which is roughly, as you know, 36, 37, 38 miles an hour. And he says, if I remember correctly, which would be seen from this report, the connecting piece between the filling cap and the tank, in other words, the filler tube, some of the fluid got loose, came off, seeped out. The part came off. I would assume that the fluid flowed into open space. This was a test between two cars. The 106, he means 1600, was standing. It was a target vehicle. They hit it with an 1800, causing this damage. There had been some other tests as well. And they conducted these tests because there was some concern about auto safety. Well, there was quite a bit of concern about auto safety because the federal motor vehicle standards were being discussed. And at this time, the major concern, the only standard available was a GSA standard for rear-end collisions that was 20 miles an hour against a 4,000-pound moving barrier, not losing more than 1 ounce a minute. Eventually, that GSA standard became Federal Motor Vehicle Standard 301. Achleitner continues to tell us he thought the placement here was safe, that the tank was secure. He says there are several dangers. The tank can be deformed. There are several sources of ignition in this particular area. And his deposition was corrected, and you'll notice that August Achleitner signed. And if you look to the right, it was signed before him in Munich, and it was authenticated by Dr. Jost Schmidt back in 1980. We also had deposition testimony of another one of their engineers, Mr. Holmbach. Excuse me for a minute. Because we're videotaping, can I ask you to move over just a little bit? All right. Holmbach testified that there were some crash tests done in '66. The first test they conducted, the crash test, they wanted to test the survivability of the passenger compartment. They did that pretty well, but as they did it, those tests showed that the rear end was particularly soft, and Holmbach was aware of that testing. He says that there was destruction of the fuel system, and what was the extent of the destruction? He says the fuel tank was damaged in the rear end. So we know that BMW engineers knew from the 1967 tests, that Holmbach knew along with the other engineers that placing this tank where it was going to get crushed. And he did say it was feasible. It was feasible for that gas tank to be placed in a position forward and over the axle where it would be safe. And back in 1966, when this vehicle was first designed and sold, that could be done. Wolfgang Lang, another engineer, he's been there since '72. He says the tire had to be placed somewhere. He says one of the reasons we put the gas tank on the right side was because the left side is most often hit. I said to myself, they sold this vehicle in England, did they not? In England, just the opposite is true. Here's an ad. If you can see it, the steering wheel is on the right side. This is the British version. It's the right-hand drive. The gas tank in England is still, guess where? On the right side, of course. So, I mean, any port in a storm when you need a good excuse. He does admit there is no protection from the bumper. Of course, you can't deny that whatsoever. Mr. Gebler is another chief engineer with their chassis division. He told us that BMW had actually manufactured a vehicle with a gas tank over the axle in the early 50s. So BMW had that technical capability. Isn't it a fact that one of the reasons you put a tire in the left rear is to make it safer? And he tells us yes. And he says that back end is really less protected, and it's more vulnerable in an impact. Clearly admits what he has to. He tells us that they could position the gas tank over the rear axle, and in fact had done so in some other vehicles. He says it would be much safer if the tank was placed over the axle because it would have the protection of the rear end and of the wheels on both sides. Were you gentlemen familiar with the fact that other automobiles were built with tanks located above the rear axle? He said yes. And he says at the bottom, you'll notice here, Have you ever seen such a design prior to 1960? I can answer this question very simply. BMW had a car with the tank above the axle, and that was between 1950 to 1960. So the technical ability was there. As you've done, we conducted a major literature search, not only to get background on the testifying witnesses, but also to get a better understanding of the vehicle itself. And that literature search helped us come to see some very interesting pieces. The defense expert in this case was Dave Blaisdell. He used to be with Derwin Severy. Derwin Severy was at UCLA during the initial crash testing. This was a 1967 crash test, full-size Fords. He was doing seatbelt studies. It was published by SAE, as you can see, in 1968. And Derwin Severy in 1967 rear-ended full-size Fords. You can notice the gas in the middle photograph. I'll call the gasoline spilling in a cloud on this rear-end collision. He actually ignited the gasoline. The defense in this case was, geez, we didn't have a big fire trail, so obviously the gas didn't come from the initial separation, but came from the rollover. That was part of the defense approach here. But as a practical matter, Derwin Severy suggested back in 1968 that the gas tank should be over the axle like it's in most cars today. Harry Robertson was one of the pioneers. He's still practicing. He's in Arizona. Harry had done a lot of helicopter and airplane crash work, and he did all of the initial work that led to gas tanks being as safe as they are today, basically using what they had learned in air crash studies about making them safer. Neva Johnson testifies in gas tank failures in fire cases. She was one of our experts in this case. Neva's background was as a chemist. She had worked for B.F. Goodrich on bladders with Harry Robertson, bladders for helicopters, bladders in airplane gas tanks. She conducted this study for NHTSA in 1970. Her background is in chemistry. She crashed a couple cars. She inspected some cars. This paper is a seminal paper on gas tank, what needs to be done to make them safer. This literature was widely available in the late 60s. It was really coming into its own in 1970. The foreign articles, this article here was by Luigi Locati, Fiat. He had conducted a number of tests, and one of his cohorts, Mr. Franchini, had done a car crash fire investigation. They had presented their paper in Munich in 1966. I'm pretty sure that BMW attended that party. Here's the paper itself, Car Crash Fire Investigations by Franchini. Franchini developed the use of rockets to accelerate vehicles for test purposes. And that was the modality that was used by Ernst Fiala when he tested these BMWs at the University of Berlin. Swedish burn studies. The Swedes have had excellent documentation of vehicles and accident analysis. Their reports show that there are fires, and the number of fires in the 1960s vehicles could be easily prevented. The literature that we looked at showed that BMW has attended numerous conferences. Here on this agenda, which was one of the experimental car conferences that were held in Europe, I see that Ernst Fiala was working for Volkswagen at the time. Stork, Mr. Stork, whose name that you saw on that letter by BMW, he had presented a paper on the cost effectiveness of internal regulations. He notes here that the American regulations are far too stringent and too costly. And it was interesting to see that Mr. Stork and Franchini were here on the same program, so that we know that this European community of experts regularly meets to discuss. And Mr. Stork, isn't it true that Franchini had written the seminal paper on car crash fire protection in 1965? Stork had published also Elsholz. Elsholz had reported to the United States government in 1971. There's a list of his publications that you can call up out of your own computer databases. We also know that Bernhard Oswald, who was mentioned in the course of this litigation. Here are the list of people who went to this conference. Elsholz was there, Stork was there, Oswald was there as well. At another conference from BMW in München, we have Oswald and Stork also participating. Elsholz had published a number of papers, and we know that Elsholz reads SAE documents because in his own publication, he cites SAE papers, including the 1970 vintage materials where we know the Severy and the Blaisdell crash prevention materials were commented on. Ernst Fiala is a professor at the Technical University of Berlin. It's publisher Parrish. He has a number of publications on aspects of passenger safety. Mr. Stork still works for BMW in Munich. If you'd like to call him, that's his phone number. Mr. Elsholz still works for BMW. He's still in Munich. There's his phone number. Professor Fiala works for Volkswagen. He lives in Austria. His fax and phone number in there, and his secretary is Ms. Goretsky, whom I've had an opportunity to chat with over the phone. It's interesting that all of these people who know the most about BMW vehicles, Stork, Einholz, and Fiala, they've crashed them, they've reported on them to the federal government. None of these people were disclosed as experts by BMW in this case. And that was going to be part of the litigation theme. It's not what you see, it's not what you hear, ladies and gentlemen, it's what you don't see, it's what you don't hear. Why do they give us experts who really don't know anything about this vehicle? BMW, the Posey law firm, they're a large plaintiff shop in Portland, Oregon, actually had tried a BMW 3 Series. Gas cap came off. Harley Kopp was their expert. I learned about the case through Harley. I went to Oregon, bought a copy of the trial transcript, went through it and read it, and lo and behold, guess who testified? Jost Schmidt, again. Herr Dr. Schmidt reported that he was a lawyer. He's in private practice since August of '76, began with BMW then. He's in-house counsel. He brought some documents to Portland. Among the documents was Exhibit 258. Exhibit 258 was a very interesting item. That was a crash test. He had translated it into English. If you would like to see a copy of 258, it's here along the right wall. It's blowing up for your edification. And defense counsel in that case put 258 into evidence, and it was received. That was important because there had been a confidentiality order on documents in the Portland case. So only lawyers involved in the case or those associated after the lawsuit was over had a chance to look through them, and the protective order was a gag. Those lawyers who have seen all those records cannot talk about all of those records that are available. But this one was put into evidence, and under Oregon law it became a public document. And here's a copy of it. Exhibit 258, crash tests on completed vehicles. They crashed model 1600s. And here we find out for the first time why they crashed them. Because a special effort was made to adhere to the figures established in the GSA. That was the first GSA standard that came out in 1966. The Germans were looking closely at it. This is test number 7. A BMW 1600 was rear-ended. They did not have the spare tire in the back of it. They took it out, they rear-ended it, and you'll notice at the second last line, gas tank very badly deformed, leaky, rear wheels blocked by parts of carriage. Sounds like the Chin BMW, sounds like the Sugarman BMW, right? Rear wheels blocked. This technical language here you don't have to understand, but if you look through it rather quickly, you'll see that of the total energy units, some 6,460 units of kinetic energy that were transformed into crush damage, 500 of those units were transformed into the front end of the bullet car. The other 6,000 were absorbed by the rear end of the target BMW. Over 90% of the crush energy was absorbed by the 1600. That means to any engineer that this is an extraordinarily soft rear end. This was the standard. It came out in July of '66. The test procedures, they wanted a rear end collision directed at the center line of the fuel tank, at the center line of the fuel tank, not the center line of the vehicle. When we tested this, we used a '74 Camaro. We put it on the center line of the fuel tank to see if it would meet this standard. There were a number of vehicles that were being sold in Europe and around the world where gas tanks were located over the axle. This is a '68 Renault Caravelle. You'll see above the wheel is a square figure. That's a gas tank. The Saab has an over-axle gas tank in the '60s. This is a 1954 Tpr Vega. It's basically a Chrysler vehicle that was reconfigured in Europe. Mazda Cosmo Sport. You'll notice the gas tank is over the rear axle. In this Triumph, the gas tank is over the axle. And here's a little better shot of it showing the gas tank itself, 1965 Triumph. It doesn't take any great brains to know that you should keep a gas tank out of the crush zone. The Rover also had a gas tank. There's a trunk of a Rover. Here's the filler tube of the Rover. Saab. This is a list of all the vehicles in which the gas tanks were located over the axle. You'll see that some goes back as far as 1960. Audi, Mazda, Mercedes-Benz, Chrysler, Datsun, Fiat, Subaru, Toyota, General Motors vehicles, including the 1969 Ford Capri, which was designed by Harley Kopp. Joachim Frings was their testifying engineer. He basically says this car was a very strong vehicle. He had crash-tested cars for Audi, came to work for BMW. He was in charge of quality control. Tells me there are more than 2,000 engineers that work for Audi. He's a full-time employee. He had come to to BMW in 1977. It's interesting that they couldn't produce anyone else. He did read the transcript in Sugarman. They had that available. He thought there was a case in New York City where he had read a transcript. He recalls a test or two, but he's relatively vague on what those tests were. He really didn't look into it. He was more concerned about their production testing. We're going to be having a meeting. I'm going to move forward through these slides because we wanted to start just about now. There's no need for me to go to a large part of this. He does work with Elsholz. He tells us there were something like 108,000 BMWs, first one into production in '66. They keep a library of all of their materials. 108,000 sold in the United States. He contended there was a rollover here in this particular crash test. Dave Blaisdell was a defense expert. He said the speeds here, the speed differential was 28 to 38 miles an hour. He would put the Camaro at about as high as 98 miles an hour at the point of impact, but the differential was 79 to 87 miles per hour was the range. Other BMWs, when they roll, show matchboxing. If you look at the tops of these vehicles, you notice they are skewed. There's another, someone else's BMW that's been rolled. There's a rolled BMW. But in our particular vehicle, we don't have any of that matchboxing. None of the matchboxing. And it was because we didn't have any matchboxing, we decided to conduct a crash test. These are the pre-crash lineup. You notice we have a 74 Camaro lined center line with a fuel tank. There's the fuel tank and the filler tube before the crash. Here's the crash test sequence. These particular photographs are from the 1,000 feet a second high-speed film. We can see that the gas tank itself fails within the first 10 milliseconds. This is at 23.5 miles an hour. You'll see the gas tank is gone. You'll notice there's fluid spilling. If you look at that right rear tire, there's something coming down there. That's Stoddard solvent. We didn't use gasoline. You can see the gas tank is gone within about 15 milliseconds of this crash. The vehicles continue and come to rest. This was the damage to the 1974 Camaro in a 23.5 mile an hour collision. Virtually no damage. This is the damage to this particular vehicle. Look at the severe crush. This is the Sugarman vehicle. Compare that crush to this crush. This is our Chin BMW. Compare that crush, and you'll see that it's virtually identical. This is another BMW that we found. This vehicle had rolled twice. It did have scratch marks on it. Made us think twice about whether or not our BMW had rolled. But the real key here was the failure to warn. I think this instruction, this is 3.10, is ignored by many people. There's a very important word here, and that's the word might. Whenever it's foreseeable that someone might be injured, you have a duty to warn, to take preventive action. This is the waiver. The case settled for $1,680,000. We chose not to try it. This was signed on February 23rd, and after the check cleared, we held this press conference. Paul's very adamant about establishing a burn foundation. Of the things I learned in this case, I'll take 1 or 2 minutes just to share them with you. One is, don't immediately jump to a conclusion when you see something that must be the way it is. 3 or 4 lawyers, 3 or 4 experts saw this crashed BMW and concluded that it was high speed. As it turned out, the speeds were on the order to 20 to 23 miles an hour. I also have brought here today, and you've had a chance to see, the actual hard copy photos of many of the slides that were present in the presentation itself. You're welcome to look at them. I would encourage you that when you're going to trial, it's important to dominate the room. And I put up these exhibits in this room so that you can see what the courtroom might have looked like if this case was actually tried. You'll notice a number of the photographs are 11 by 17. It's a rather unusual size. I chose that because those are all color Xerox. And you can have those made and blown up for $4 or $5 a piece instead of spending $30 or $40 for hard photographic blow-up. They are very good quality, and it's easy to prepare for trial because you don't have to identify negatives. You can simply take your 3x5 photographs that are in your photo file. We had over 900 photographs in this case. You can take those photographs, send them out, have them copied, have them blown up, and I welcome you, and you're encouraged to look at those that are in the back. This was an clearly hardly well-prepared, hard litigated case. There were over 40 depositions. The actual costs were $286,000. I wouldn't encourage you to venture into these kinds of cases without fear and trepidation. But I would encourage you to look at them very closely. There are thousands of these BMWs still on the roads of California, and as you leave here this morning, you'll notice some photographs. I photographed myself over 200 BMWs in the Bay Area during a 3-month period. So that's the story of the Chin versus BMW, some ideas for demonstrative evidence in a products liability case. We have a very important membership meeting here for CTLA. I see our president, Larry Drummond, is here. Larry, we're just about done. Can we take a question, or do we want us to go over?
I don't mind a couple of questions. If we could have all the members just stay. This meeting is going to take 5 minutes, but we do need a few folks here.
Good enough.
Members, stick around.
Go ahead.
What did BMW say as the number of other incidences said it happened?
Sugarman only. We didn't have any foreign data. We know that 500,000 of these cars were sold outside the United States without any data at all. And there's such a soft rear end, I doubt that many people would step forward with a complaint. Because your natural inclination, my natural inclination when I looked at it, was to say, this was a big hit. This looks like 40 miles an hour. I mean, that was clearly the defense here. So it's not what was reported to them, it's how many actually occurred, and we don't know. And in terms of proof at trial, they can't come up and say, we don't know of all these others, because you can't prove a negative. And you can exclude that with an in limine motion. Anyone else?
Why did you choose to settle this case for such a small amount, given the possibility of punitives?
No punitives were available in this case because the complaint was served under treaty, which doesn't allow us to collect punitive damages against BMW AG. Secondly, these injuries were horrific. This is a $5 million case. Pardon me, it's a $500,000 in injuries. It's a $5 million case in terms of the injury itself. This man was hit at night at high speed by a drunk who was a convicted felon who hit and ran and left. The car burned, the car rolled, at least according to one theory. It may not have rolled, but if it did roll, virtually no vehicle can retain any gas in a roll. If the jury found the vehicle rolled because of those scratch marks on the side, there was a probability of no verdict. There was a probability the jury might find the sole proximate cause of this accident was John Reiser rear-ending Paul Chin. As far as I was concerned, Reiser was the cause of the collision. BMW was the cause of the burn. And I can tell you in this case, the client made the decision. And a man as badly burned as this, with $1,680,000 on the table, the number is peculiar because it was in Deutschmarks. But it was his decision, and we settled it. If he had been rear-ended by someone at daylight, a granny, driving a nice conventional little vehicle where we had better verification of speed, where the speed differential was objectively available at 15, 20, 25 miles an hour, and if we had the Hulk, then in all probability this case never would have settled. It probably would have proceeded to trial. Thank you very much. Larry, it's all yours.